Hi everyone, my name's Sam Michaels. I'm a Toronto-based lawyer. I work mainly in business and employment law, and I'm here to talk to you about what to do when you've been fired from a job, when you've been laid off. So there's a couple different options that you can take after you've been fired, and the first thing to do is to review the circumstances of the firing. So what do I mean by that? So the first thing when you've been fired is you want to go back and look through the most important documents that are going to sort of set the strategy going forward. So those are going to be the termination letter and your initial employment contract. If you don't have those documents, if they don't exist, it's okay. But if they are there, if they are, somewhere in a back drawer, or you just handed that termination letter, first step's going to be to review them. The employment contract might say, if you're fired, you're limited to this termination pay. Unfortunately, that's probably going to be the end of the story. You may want to have a lawyer look at the employment contract, see if maybe there's a clause that is an illegal or invalid clause that could open up some other opportunities for recourse. But generally, if the contract says, if you're fired, this is how the payout's going to work, you're probably going to be limited to that payout scheme. So after the employment contract, you want to take a look at your termination letter. Let's say the termination letter offered you, you've been working for a year and they offer you 6 months of termination pay. That's a pretty good settlement offer. It's right around, even beyond what's normally offered. So looking at the termination letter, I think one of the very first things you want to gauge is, was an offer made to me and is that offer fair? Am I okay to accept it? And if it's a good offer, maybe that's the end of the story. You take the payment and move on to another opportunity. If you're not happy with the offer, or if there's no offer, if they say there was a just cause firing, you can kind of move on from there, see if there's a claim to be made. So if a firing was for just cause, an employee is not entitled to termination pay. Just cause would be somebody stealing from the employer, somebody getting in a fight with a customer. We're talking about really more extreme things that pretty much in anyone's mind would justify a firing. So if that's the situation and you've been fired and you know that you did something that really was maybe out of the ordinary or was really wrong for the employer, you probably don't have grounds to make a claim. On the other hand, if you weren't given a reason, or the reason is unfair or falsified or maybe manufactured, then you may want to look at making a claim. And there are two main avenues to make a claim once you've been fired. There's the Employment Standards Act claim through the Ministry of Labour, and there's a court claim through the Ontario court system. There's pros and cons to each, and I'll sort of go through it in very brief summary form. At the Ministry of Labour, the ministry office are tied to the minimum entitlements. For termination pay, that means basically 1 week per year. So on the negative hand, you're not going to get, or I should say it's very unlikely that you'll get punitive damages or damages for emotional distress or anything over the minimum, right? They'll say you were employed for 2 years, that's 2 weeks of termination pay, that's what you're owed. On the positive though, because it's a mechanical system, there's a lot less risk. If you worked for two years, you're going to get your 2 weeks of termination pay from the ministry. The other option is to make a claim through the court. And if you make a claim to the ministry, you can't claim to the court. If you make a claim to the court, you can't claim it through the ministry. So you have to choose. If you claim through the court, you can claim for a lot more money. You can go over those minimum entitlements that week per year. But in the court system, it's a lot less mechanical, and there's a lot more risk that you could lose the case and even have the employer's cost assessed against you. So you really have to gauge, what is the strength of my case? If the case isn't very strong, it may be more suited to Ministry of Labour. If there is a lot of strength, but it's more in the intangible things, less so than the mechanical parts of the employment, then it's probably better suited to court. So overall, when you're fired, first thing, look at those documents, think about the circumstances of the firing, and if there's a claim to be made, it may be worthwhile to go either to the ministry or the court. For any of these situations, if you've been fired, strongly recommend reach out to an employment lawyer, get the situation reviewed. There's lots of lawyers that offer a free initial consultation, or you can go to the Law Society of Ontario referral service, and they'll connect you with a lawyer who'll give you 30 minutes of a free consult to let you know if you have a claim in the first place.